Good evening. Welcome to the 2021 Lumbar Spine Research Society Instructional Course Lecture Series. My name is Mike Lee. I'm an orthopedic spine surgeon at the University of Chicago. And together with Dr. Jeffrey Chou, orthopedic spine surgeon from Northern California, we'll be moderating these sessions. In the course of any surgical spine practice, there is an inevitable overlap between the legal world and the spine world. This can manifest in a number of different ways. Intellectual property, conflicts of interest, personal injury, and of course, medical malpractice. We've prepared a three-session instructional course series examining this overlap of the legal world and the spine world today and the following two Tuesdays. Today's session will be an overview on malpractice claims. Next week's session will be a little bit more granular with perspectives from a plaintiff's attorney, a defense attorney, neurosurgeon, and orthopedic spine surgeon. And the third week, we will get away from medical malpractice and look at other non-legal matters, such as conflicts of interest, intellectual property, personal injury, and expert testimony. Next slide. These activities are eligible for CME credits. If you'd like to claim CME credits, you can visit lsrs.org/ICL for more information. They are per session. Next slide, please. We have a fantastic faculty lineup for you today. Our panel of speakers, our first is Dr. Dean Chou, who's a professor of neurosurgery at the University of California, San Francisco. He'll speak on the current state of lumbar malpractice spine claims. Our next speaker is an attorney from Chicago, Mr. Jonathan Cavins, a partner with Brennan Burtker, who will give a global view or give a presentation on the global view of the legal process of a malpractice claim. And our third presentation for the evening will be Dr. Bruce Darden from OrthoCarolina in Charlotte, North Carolina, who will provide other perspectives during medical malpractice claims, such as a hospital perspective. Next slide. Please use the Q&A function in your Zoom to ask questions. There will be a live discussion after all presentations have been given. However, the presenters, if they're not presenting, may choose to respond to your question in the Q&A box. So without further delay, I'd like to introduce or bring about our first speaker, Dr. Dean Chou from University of California, San Francisco. Dean, if you can start sharing your screen, we'll go ahead.
Great. Thank you, Mike. Thank you, Mike and Joe, for inviting me. I will share my screen here. Great. So I'm going to talk about the current state of lumbar malpractice spine claims, sort of the lay of the land. These are my disclosures, which should not impact the content of this talk. So how much money are we talking about? So if you think about the numbers, in 2008, medical liability accounted for $55.6 billion. So 2.4% of all our healthcare dollars somehow went to medical liability. But that does not include defensive medicine, right? Ordering extra tests, MRIs, all these sorts of things that you do to protect yourself may cost up to $210 billion annually. So there's a lot of money spent on this issue. Well, what is the average payout? The average payout for neurosurgery is $439,000, which is the highest of all medical specialties. And if you think about the frequency, 20% of all neurosurgeons will be named as a defendant in a malpractice claim every year. So every year you'll have about 20% of the entire practice of neurosurgeons named. And nearly every single neurosurgeon will be named as a defendant by the age of 65. Well, this is a mixed audience of orthopedists and neurosurgeons, and you can say, well, I'm an orthopedist. This doesn't apply to me. Well, actually, we're all in this together. So the lawsuit rates are the same for spine, for orthopedic and neurosurgeons. There's no difference. We get attacked the same regardless of specialty. So the rates are going to be the same. And the payouts are comparable. So whether you're orthopedist or if you're a neurosurgeon, the payouts are very comparable between subspecialties. Now, how does spine compare to the rest of orthopedics? So the average payout for peds is higher. Spine is the second highest, and then oncology is the third highest. What about the frequency? Frequency is going to be fracture fixation is number one, arthroplasty number two, and spine is third. So we want to pay attention to spine because it's definitely a big factor, whether it's orthopedics or neurosurgery. Now, what about, do spine surgeons win? We hear that a lot of the time that it's in favor of the defendant. 75% favor the surgeon. But if, as a spine surgeon, you lose the case, the settlement can be pretty significant. 2.384 million for settled cases, and then 3.9 million if it goes to jury. And surprisingly, informed consent is really important. And we do this every single day when we talk to patients and we think we're doing a good job. But 34% of cases were about lack of informed consent, meaning that the patient felt like the risks and benefits weren't properly explained. You know, they may say, if I had known this would have happened, I never would have signed up for the surgery. So up to 1/3 are really about informed consent. Average payout is $2 million for consent cases compared to 3.6 million for intraoperative performance cases, meaning what happens in the operating room. Now, what constitutes negligence, right? So the negligence definition is something that we all should be aware of. It's conduct without wrongful intent that falls below the minimum degree of ordinary care imposed by the law to protect others against unreasonable risk of harm. Now, we want to make sure we think of these four aspects of negligence, right? Injury, duty, breach, and causation. Injury is basically emotional or physical harm to the patient. Duty is a reasonably well-qualified physician in the same or similar community would bring to a similar case under similar circumstances. It also means a reasonable person under the same circumstances would recognize as necessary to avoid or prevent an unreasonable risk of harm to another person. Breach. So breach is when the defendant departs from the required standard of care and fails to act within reasonable prudence. And you notice there's a common theme here of reasonable. And then causation. The actions were both the actual cause and the legal cause of the plaintiff's injury. And those are the four components of negligence. And if you keep those four things in mind, that certainly it can help you guide your way through this whole practice and avoiding lawsuits. So what are the main reasons for getting sued? So the most common reason was improper performance, meaning what you did in the operating room. Either you didn't safely protect the nerves, or there's neural injury, dural tear, venous injury, whatever it is, but it was improper performance of what happened in the operating room. And you think, oh, this is going to be the big horrendous big 5-liter 10-liter cases with revision with 3-column osteotomies. Those are the ones. It's actually not. The most common types of pathology are degeneration. So most common prevalent condition was intervertebral disc pathology, degeneration, and displacement. And you want to think about, you think, oh, it's just a microdisc. I'll bang it out real quick and I'll be done. And it's never just a microdisc. For the overwhelming procedure associated with lawsuits is lumbar laminectomies for discectomies, which accounts for nearly 55% of all cases filed against orthopedic surgeons. So again, it's the simple bread and butter degen cases that can really add up and really be a big issue. And part of the reason is that because they're so simple, the standard is so high. We're held to a much higher threshold of outcomes. And what are the reasons that people will sue? They want to hold the physician or health system accountable. They want to seek an explanation for the adverse outcome, or they want a financial reward. And going back to neurosurgery, you know, if you say, oh, those neurosurgeons are getting sued because of all these brain cases, those subarachnoid hemorrhages, those crazy tumors, it's actually not. If you look here at the presenting medical condition, the 6 of the 7 highest, most common presenting medical condition to neurosurgery is spine. Degeneration of the disc, back disorders, spinal stenosis, fracture, spondylosis, and cervical problems. And only number 7 does it come down to cranial issues. So again, spine is a huge issue in neurosurgery with regard to lawsuits. We know that in the recent years, the bigger payouts have occurred. Cases over $500,000 have increased. Cases less than 250 have decreased. And spine is a big target. Like we said, 60% of the lawsuits involve spine surgeons. And the next most common, only 15%, was general neurosurgery. So again, degenerative pathology really is a target. And the most common conditions are disc disease, back disorders, and spinal stenosis. And as spine surgeons, we think, oh, these are all bread and butter, simple cases. But again, these are the areas that are targets for lawsuits. Altogether, these 3 conditions comprise 40% of all medical malpractice cases for spine surgeons. And then the other thing to think about is that, you know, these aren't these crazy cases that come in through the ER with, you know, BMI of 50, getting involved with some huge MVA, and you can barely see and you can't do the surgery. The majority of these are elective spine surgery, right? 79% were elective spine cases. And the big reasons are lack of informed consent, failure to treat. So whether it is inadequate decompression, whether it's timing of surgery, whatever it is, it's failure to treat, and then failure to diagnose. You know, if a patient comes in with lumbar stenosis and they have myelopathy on exam and have gait disturbance, and you know someone didn't image their cervical spine or thoracic spine, so the failure to diagnose is another issue. But again, the majority is elective spine surgery. Again, procedural error, meaning you didn't execute the surgery properly, was more frequently cited in elective cases. So you do a lumbar lami, something bad happens, that is more frequently of an issue than it is for emergency cases, right? So if the emergency case comes in and it's hard to do the case because they've got abnormal anatomy, the fracture is abnormal, the tumor is abnormal, and you had to do the surgery, there's a little bit less of procedural error frequency than it is for elective spine surgery. Wrong level surgery, this one's pretty obvious, but the database calculated that 0.041% of wrong level surgery. It's very rare, as we all know, but the payout can be high as $1.5 million. Cauda equina syndrome. This is a term the plaintiff attorneys love. The average payout is $1.57 million. You have to keep in mind, though, 73% did not present with the defining bowel and bladder dysfunction, and 83% of the cases did not have classic cauda equina syndrome. So you have to keep that in mind, that just because they don't have the triad of the entire cauda equina syndrome that is presented in the textbook, again, this is something to consider, that the plaintiffs are winning these cases, even though they don't meet the classic presentation. Death, not very common, 17% of cases. The average payment is $450,000 if the patient dies. Now here's another hot topic, is misplaced lumbar pedicle screws, right? This is something that happens. It's not zero. It happens to everybody who does spine surgery. You know, we're not perfect. But again, it's $1.5 million average payout. There's cognitive load of worrying about these lawsuits, 4.5 years on average before these cases finally settle and are closed. And 30% are actually favored for the plaintiff. So again, this is something to consider, that misplaced lumbar pedicle screws are an issue and something to consider. Dural tears, right? So we all get these. It happens to every single one of us if we do spine surgery. And only 56% rule for the surgeon with $2.7 million payout. And the main reason that people lost these lawsuits is delay in diagnosis and treatment. So a patient comes in, they've got headaches, and the surgeon doesn't address it. They're leaking stuff out of their wound, and the surgeon thinks it's, oh, this is just seroma fluid. Again, it's the delay, and then they get meningitis or some other issue. It's the delay in diagnosis and treatment more likely led to a payout. But reoperation did not necessarily compromise the surgeon's verdict. So if you found the dural tear, you took them back to the OR, you fixed it, that did not actually increase your rate of losing a lawsuit. Catastrophic complications, as you can imagine, if you have something catastrophic, spinal cord injury, brain injury, or death, the payout is much, much higher. 54% will rule for the defendant. You're much more likely to lose the lawsuit. Again, ortho and neuro, it's the same. We're all in this together. And then finally, just to go over the cognitive load of what these lawsuits do to us. The time from a lawsuit is to closure is 3.5 to 5 years. These are mentally exhausting. You can't really relax. Even if you're on vacation, this is in the back of your mind at some point. So again, you have to think about, how much cognitive load is this stuff really weighing on us? So in conclusion, we need to be aware of medical legal ramifications of our job. Patient care is number one. Informed consent is critical. And spine surgeons, what can we do? It's really, we just spend time properly evaluating the patients, executing the surgery, doing the best job that we can for the patients. Thanks very much.
Thanks, Dean. I think my blood pressure just went up 30 points, but it was a fantastic talk. Move on to our second presentation of the evening. Mr. Jonathan Cavins, attorney in Chicago, will give us the legal perspective on a malpractice claim from start to finish. These are things that I was never really aware of until I was actually in it. So without further delay, Jonathan.
All right, good evening. Thank you to Dr. Lee and Dr. Ko for inviting me to speak tonight. I am going to try to cram about 3.5 to 5 years worth of information into 15 minutes. So I will do my best to not speak too quickly. Sometimes I tend to do that, but I'm here to talk about the anatomy of a medical malpractice claim, if you will. And as the prior presentation demonstrated, where this really often starts is with the injury. This can be a real or a perceived injury or bad outcome in the context of medical care and treatment. It often occurs with sudden and acute events that might occur in the hospital for spine surgeons like yourselves, often surgical complications intraoperatively, post-operative complications like infections, or we talked about dural leaks, failure of hardware, and a lot of times there's just dissatisfaction with recovery. I think a lot of the cases that we see the patients, and this kind of actually goes, I think, towards the concept of the informed consent issue. A lot of times the patients will just feel dissatisfied with their outcome. They thought that they were going to have a more optimal outcome, and they feel like they didn't because the doctor must have done something wrong, and they're looking for a reason that the doctor did something wrong. And I think that's sort of often the impetus for the initiation of a lawsuit. So when a patient either has a real or perceived injury, they will often consult with an attorney. And that is known as a plaintiff's attorney. That's the attorney that represents an injured party. And they'll consult with the attorney. It will either be the patient or the patient's family members if the patient is no longer alive, if they died either because of the medical care or for an unrelated reason afterwards. They'll consult with an attorney to determine a couple of things. First of all, do they have a potential claim? Is there a possibility of malpractice for the case? They'll assess the likelihood of the success in the case because unfortunately, sometimes attorneys have to look at it from the perspective of if there's not a high likelihood of success, whether there was negligence or not, they won't pursue the case. Then they will often consult with experts to see whether or not there is a case. Lay people have a difficult time sort of judging and assessing whether or not a physician has committed malpractice. So they may consult with experts to determine whether or not there is a case there. And sometimes they, I think more often than they probably should, attorneys will look at the value of the case, because even in cases in which there is an actual error that could be pursued, if the case doesn't have the type of value that can make the attorney money or is worth pursuing, they will decline it a lot of the time. So once they meet with the attorney, then they may decide to either forego litigation or proceed with litigation. Sometimes before litigation is filed, there's what's known as a pre-suit investigation by the defense side. This most often occurs when there's an injury or an adverse event that occurs in the hospital. And that's because typically the hospital is sort of acutely aware of the fact that the incident has occurred. Sometimes the patient will retain an attorney who might send a letter to put the hospital on notice that they've been retained, even though they haven't filed formal litigation. And that can prompt the hospital to retain counsel. We as the defense lawyers will be retained to review records, investigate the facts of the case, interview the physicians and the nurses and the other providers involved in the care, and oftentimes to retain experts and consult with the experts to review the case and evaluate the care from our perspective to see whether there is exposure or if there is a possibility of defending the case strongly versus if it's a case of probable liability versus possible liability versus questionable liability. Then comes the complaint. If the patient decides to pursue litigation, they will file a complaint. And this is the document, or the pleading, as we call it, that initiates the litigation. And the complaint sets forth the allegations of medical malpractice. Most states, I believe all of them actually, require what is known as a certificate of merit or an affidavit of merit. And the purpose of this document is that it goes with the complaint, and it's allegedly intended to reduce the amount of frivolous lawsuits. And the idea is that lay people like attorneys don't know how to evaluate whether or not there's medical malpractice. So the law requires them to consult with an expert and have an expert author a report that sort of discusses the nature of the care and treatment and asserts whether or not there's a meritorious cause of action that it can at least be pursued. It will discuss what the standard of care is and how there were deviations from the standard of care and how those deviations may have caused the injury. Some states only require that the attorney file an affidavit saying that they've consulted with a physician, but many states require that the physician actually author a report. Although in states like Illinois, it's anonymous. They don't put the name of the physician on the report, but it has to lay out that the physician is a licensed physician with experience in the area of medicine at issue and discuss the medicine at issue and why there is a meritorious cause of action. While the stated purpose of this is to prevent frivolous lawsuits, this is a very low threshold. Many cases proceed past this stage that often really don't have merit, but as long as they have a doctor who will say there will be or there is some merit, they can proceed forward. Then there's service of process. And this is what happens when the defendant is served with the summons and the complaint. And that's basically how you become notified that you are being named as a defendant in a case. This is most often done by personal service, usually by the sheriff or the process server. And it's your classic "you've been served" experience. And at some institutions, especially the academic institutions that I represent, a lot of times they will allow the attorney, if one has already been retained, to accept service on behalf of the defendants. And that really just sort of saves the defendant the awkward experience of being served. Sometimes these people show up at your house at dinner time or track you down on the street, and they'll allow us to just accept that service to sort of forego that formality and then be able to proceed with defending the case. So what do you do if you are served with a summons and complaint? So the first thing that you should do is the first thing you should do is take a breath and realize that there are lawyers out there like me who are here to defend you. But after that, you should notify your malpractice insurance provider. For those of you that work in medical centers or hospitals, that's often the in-house legal department or the risk management and claims department. And for those of you that practice in private practice, you will have private practice malpractice insurance, and you will notify your carrier that you have been served with the summons and the complaint. And then either the hospital or the malpractice carrier will retain counsel, like me, to defend the case in all of its aspects. The attorney will then file what's known as an appearance, and that basically just notifies everybody, hey, I'm the attorney representing these defendants or this defendant in the case, and you have to notify me or give me copies of all of the documents in the case throughout the litigation. And then your attorney will prepare a responsive pleading on your behalf. Oftentimes it's a motion to dismiss to try to get rid of the case. And there's many different legal reasons for that. And there's many different strategic reasons for doing that. Sometimes the certificate of merit isn't adequate, doesn't really lay out how somebody allegedly malpracticed. Sometimes there's statute of limitations issues. All of the states in the United States have statute of limitations that prescribe the time period within which a lawsuit must be filed. It's usually 2 years. I think there may be some states that allow 3 years. But if they file the lawsuit after more than 2 years after the injury was either known or discovered, they may be barred from doing that. Oftentimes, your attorney will ultimately file what's known as an answer to the complaint, where they will either admit or deny the allegations of medical malpractice. As you can probably imagine, most of the allegations are denied. Certainly, all of the material allegations of malpractice are almost always denied. It's rare that they're admitted. And they may work with the physician defendant or the nursing defendants to discuss the allegations to make sure that they're properly answering them, because it's often very fact-based. Then the initial investigation begins. And as I said, this can happen pre-suit or it can happen after suit. But the initial investigation in the instance in which a lawsuit is filed usually occurs for the first 3 to 6 months of the lawsuit. And the attorney will meet with the physicians and the nurses and the other providers, and not necessarily just the defendants who are named, but those who are involved in the care and treatment at issue and surrounding the care and treatment at issue, to learn about the facts of the case and to develop the themes of the defense. And oftentimes to learn about the medicine. We're lay people and we need to understand the medicine probably even on a more granular level than the physicians sometimes need to understand it in certain instances. So we rely on you guys to sort of explain it to us and make sure that we understand everything so we can develop a theme to the defense. And then we also retain experts to review the case, to evaluate the care. And we consult with the experts during that first 3 to 6 month period to get their input on whether they can defend the care, what the strengths of the defense are, and what the weaknesses are. And then we go into discovery. And this is the bulk of the litigation. This can take anywhere from 2 to 4 years. I've had cases that have had 10 years of discovery, depending on the nature of the case and the complexity of it. And there's basically 2 stages of discovery. There's written discovery and there's oral discovery. Written discovery is pretty standard. It consists of written questions that are often very, very standard questions. Some of you may have seen these before. And then there's what we call requests to produce. And those are also very standard. And the idea is basically just an initial exchange of information. It's to get out sort of the nature of the insurance coverage that might be there, the employment status of the individual who's being sued, and then also to exchange records and documents and imaging and other tangible items. And the attorney, like myself, will prepare all the answers and responses and then work with the defendant physician to make sure that it's all accurate and that we've produced everything the right way. And then we go into the oral discovery phase, and that is the dreaded deposition. And for those of you who don't know, this is a question and answer style examination, excuse me, where testimony is given under oath, and it's all transcribed by a certified court reporter and taken down, and it goes into the office of some lawyer who sues physicians for a living and will stay there forever. This is where all of the key testimony for trial is obtained. In examining witnesses, you'll often establish certain facts. Many times we establish opinions from other healthcare providers to either support the defense or to demonstrate the nature of the patient's care. When giving a deposition, the key is preparation. You have to meet with your attorney multiple times if necessary to go over the facts of the care and treatment and the themes of the defense. And you have to be prepared to defend your care. This is probably the single most daunting task next to trial for the defendants. It takes extensive preparation, and many, many pitfalls can arise if you're not prepared or if you're not engaged in your defense in a meaningful way. So you want to be extremely prepared for your deposition. And that often takes extensive discussions with the attorney to go over the themes of the defense. There are essentially three types of witnesses that are deposed. And I tell you this only because, or I'm sorry, four types of witnesses. I tell you this only because it's my practice that when I'm defending a physician or any type of healthcare provider, that I actually provide all of the depositions to the defendant throughout the course of litigation so that they understand exactly what's going on and what people are testifying to so that they're fully prepared when we get to trial. So there's the parties, which is the plaintiff, who's the one suing, or which will be the patient if they're alive, or a family member if they're deceased. And then there's the defendant, often the physician. And then there's fact witnesses like family members and friends, and they often talk about their lay observations, or they may talk really more about the damages, how this has impacted the patient, or how it's impacted them if they're a family member who can receive compensation for a wrongful death claim. And then there's independent experts, and some of you may have given depositions as independent experts or will give them throughout the course of your career. And these are basically the prior and subsequent treating healthcare providers. And we will depose these people to establish things like the patient's underlying comorbidities that they came to the table with, or the nature of their subsequent treatment and their prognosis and how they have recovered, or sometimes the truth is they haven't recovered. And so we depose those people to sort of get a better understanding of the patient's conditions, both prior to and after the alleged malpractice. And then there's retained or hired experts. And these are sort of the linchpin of the case, because each side in a medical malpractice case must have retained experts. And this is because the plaintiff in a medical malpractice case must prove his or her case through expert testimony, establishing that there was a deviation from the standard of care and that it caused the alleged injury. And then, of course, there's settlement, and this is sort of out of place because this can come at any time during the course of litigation. Discussions may be ongoing from the very beginning up to trial. I've settled cases in the middle of trial. And it often depends on the nature of the case as to when that settlement discussion will take place, or those discussions, I should say. Plaintiffs will make a what's known as a settlement demand, which is basically the amount of money that they would be willing to settle the case for, and that will initiate the discussions. Some defendants, especially ones who have private malpractice insurance, actually get the option to consent to the settlement amount. Whereas a lot of times in my cases, when I represent hospitals and medical centers, they're the ones that typically make the decision as to whether or not they intend to settle the case. But often they will consult with the physicians to get their sense of how they would feel about paying out a settlement, especially in cases where they don't think they've committed malpractice. And then finally, there's trial. There are a lot of things that we could talk about with trial and the nuances of it. But what I will tell you is the most important part about trial is extensive preparation, and not just what the lawyers do, but often we meet with our defendant physicians multiple times to prepare them for their testimony, to get them used to being cross-examined at trial. And then we also meet with all of the other witnesses and the experts to prepare their testimony. And then we put them on the stand and we try the case. And hopefully the case ends in a not guilty for us. And that is pretty much the 30,000-foot view of the anatomy of a medical malpractice case.
Thank you, Jonathan. That was fantastic. We'll go on to our third presentation from Dr. Bruce Darden, who will present the hospital perspective. As you've kind of heard from Jonathan and Dean, the hospital perspective may vary depending on what kind of situation that you're in. And Dr. Darden will shed some light on this for us. Bruce.
Thanks, Mike. Appreciate the opportunity to give this talk. I'd like to talk about the overview of a malpractice claim from the hospital's perspective. So I have no pertinent conflicts with this. I occasionally do review a malpractice case from the defendant's side, and this is pretty much unsolicited on my part. I'd like to thank Sarah Lincoln of Lincoln Durr and Elizabeth McCullough of Walker Allen in Raleigh, North Carolina, who helped me prepare for this talk. Because there's really nothing, unlike Dean, who had some great numbers and some great articles to quote, really looking at the hospital perspective, there really isn't anything out there, particularly, as far as in our literature or articles. So this is more of a broad brush stroke type of talk to give you some ideas and perspectives of what to look for in a malpractice claim from a hospital. And what these basically are concepts and suggestions based on the attorney's opinions and expertise. And you need to know that some laws will vary from state to state, such as reporting to a state medical board and the concepts of standard of care, which we'll touch on during the talk. So first, looking at a hospital's malpractice coverage, typically hospitals are self-insured, and hospital-based physicians may have the same insurance or they may have insurance with a different carrier. And where this can come into play is whether the hospital-based physicians will have a consent to settle clause in their coverage. Independent physicians typically are represented by separate attorneys from the hospital, and they do have a consent to settle clause typically in their malpractice coverage. It's important for you to know the details of your specific coverage. So as far as choosing counsel, hospital-based physicians, this process is completely done by the hospital, and hospitals will use outside attorneys for their counsel. Independent physicians typically will have input to their counsel. The malpractice carrier will have an approved list of attorneys, and you are able to choose from this list as far as their availability. It typically is a hard sell to use counsel outside the malpractice carrier's approved list. The malpractice defense attorneys do not represent both the hospital and independent physicians, though they can represent the hospital and hospital-based physicians. Important concept that we have to be aware of in this topic is the consent to settle clause. And the legal language of this is that the company or the malpractice insurance carrier must obtain written consent from the insured before making any indemnity payment to settle any claim prior to judgment or award. And once this consent is obtained from the physician, the company may, in its sole discretion, negotiate the terms and settle the claim. And it's important to know that written consent is not required if the insured, the physician, is deceased or has been adjudicated incompetent or cannot be located. And it's kind of interesting. I'm representing a claim where the physician has left country and nobody knows where he actually is. And if the insurer's license or practice has been suspended, revoked, or surrendered, written consent is not required for settlement. Hospital-based physicians do not typically have a consent to settle clause in their coverage. Independent physicians typically do, so it's up to the physician to decide whether the case will be tried or settled. And typically hospitals are on the same page as the physicians about 75% of the time as to whether to settle the claim. Well, why do we care about this? Well, I'll use North Carolina as an example. In North Carolina, every malpractice settlement is reported to the North Carolina State Medical Board. And as I was never really aware of, that our state medical boards are first and foremost patient advocacy groups. So they want to hear patient complaints and make decisions on the physicians and their care. And so in North Carolina, the North Carolina Medical Board investigates every malpractice settlement. So they look at it to whether there was a deviation in care and possible censure of the physician involved in the malpractice settlement. So it's very important, the consent to settle clause. And so, as I mentioned, in consent to settle, every settlement is reported also to the National Practice Data Bank. And every settlement in North Carolina greater than $75,000 as of 2008 is reported to the physician's personal site on the medical board website, even though the exact dollar amount is not disclosed. And as a position statement, the Federation of State Medical Boards recommends that settlements be reported and made public, though this can vary state to state. As some attorneys will say, this is not a business, this is only a business dispute, but to us, to physicians, we don't believe this is only a business dispute. This is something personal to us. So hospitals, as Jonathan mentioned, may be involved in pre-suit investigations. Typically, an independent physician only hears about a claim or an investigation after the claim is filed. Hospitals have policies in place that will trigger an earlier investigation and have systems to evaluate. And things that can trigger an investigation through a hospital can be patient complaints, readmissions, infections, excessive blood loss, neurological injury, wrong site surgery, or death. In these pre-suit investigations, hospitals do not always alert physicians, and the physician also may not have any input into this process. These investigations are usually handled one of two ways. The most typical is through a peer review committee, and most investigations will start here, and the process is not discoverable in the legal process. Risk management in a hospital may also initiate pre-suit investigations, and they typically have protocols in place to send complaints to peer review, and the peer review committee, they may occasionally alert risk management to this if the complaint starts in peer review. If risk management sees a problem, they will typically retain an attorney to evaluate for standard of care. And the attorney, as Jonathan mentioned, will then interview physicians and retain experts to look into the claim further. Physicians typically do not have any input into the hospital pre-suit investigation procedure. Your hospital bylaws will spell this out when and if physicians get notified. So here it's important to know your hospital bylaws, to know when in this process you will be made aware of a complaint against you and the hospital. This process is typically not always bad for a physician. It can give you a leg up on the legal process. And for independent physicians that are not employed by the hospital, this process may be advantageous, but you need to know that hospitals first and foremost advocate for their employees. Hospitals can have input as to who gets dropped from a lawsuit. The in-house counsel or risk management can have input. And what the attorneys that I talked to about this process would say is that hospitals are more likely to help or protect valued and well-liked physicians. What about settlements? If a hospital settles, it can assign a percentage or specific dollar amount to each individual name. And again, remember, this process, if you settle, will trigger a state medical board reporting and typically an investigation, depending on state to state. If a hospital settles, the amount that they settle for is typically subtracted from the physician's monetary exposure. And if the settlement is substantial, plaintiff attorneys will sometimes dismiss the physicians from the suit in that it's not worth their time or the additional money to go to trial against that physician. Hospitals typically, if they're sued, the trial will bring on media attention, especially in small and medium-sized cities. And hospitals are really adverse to negative publicity. Community opinions of hospitals may adversely affect jury pools. So hospitals do not like to go to trial. Hospitals thus tend to want to avoid the negative exposure, and they tend to settle claims at mediation. And in North Carolina, mediation is required for all civil suits prior to trial. Standard of care is also an important concept, and this will vary from state to state. North Carolina, as an example, has what's called a community standard of care. And this is defined as the duty to provide health care in accordance with the standards of practice among members of the same healthcare profession with similar training and experience situated in same or similar communities at the time that the healthcare is rendered. So an expert must be familiar both with the hospital and the community in this state that has a community standard of care. Other states, such as Virginia, has what's called a statewide standard of care. So any community, any hospital in the state is required to have the same standard of care, whether this is in Metro DC or a small town like Bedford, Virginia. They're required to have the same standards. Other states, however, will have what's called a national standard of care. So everyone, everywhere in the US is held to the same standards of practice. Regarding standard of care, hospital-based employment agreements sometimes will mention a national standard of care. And if so, plaintiff attorneys can thus pull an expert from anywhere that does not need knowledge of the community. So it's important to look at your employment agreements to see if this is part of it. As far as malpractice defense, it's always important to avoid hospital versus physician conflicts or blame. Throwing parties under the bus typically is more advantageous to the plaintiff attorneys than the defense. And the best way to avoid adverse outcomes in suits is to have all parties rowing in the same direction. So we know that hospitals have policies and procedures. They love them. And these are typically more codified than policies and procedures in independent groups. Plaintiff attorneys are aware of these and will ask for these policies and procedures, arguing that they set a standard of care. Defense attorneys, risk management departments usually recommend that these policies and procedures be listed as guidelines to avoid setting a legal standard of care with these policies. So if you're involved in promulgating these or under the auspices of these, be aware of them, be aware of what they say in their legal language going forward. Also, hospital leadership positions such as medical director, department chairman, if you're part of a co-management team, usually these contracts will have will specify your specific duties, and plaintiff attorneys are again aware of these and will use these to document non-compliance, whether they're germane to the suit or not. This is a fairly standard plaintiff strategy to make you look basically negligent if you're not basically complying with a lot of questions or concerns out there, such as signing a legal document late, or the op note late, or failing to do something. Just little simple things that make you look negligent, whether they're involved with the suit or not. But if you're involved in a hospital leadership position, have an independent attorney review your contracts to look at the language with this, so you're aware of what you have to do in these contracts. Also, our professional associations will have policies and guidelines, and while they're not strict standard of care, just like the policies and procedures that the hospitals have, plaintiffs' attorneys will be aware of them. So if you're a hospital-based physician and the hospital is involved in a suit, you need to be a good citizen. Again, there are multiple examples of the hospitals not vigorously defending physicians that are thorns in the hospital's side. But if you're well-liked and productive, hospitals usually will go the extra mile for you. So going forward, these are important concerns to be aware of. Your employment contracts, leadership employment contracts, the hospital bylaws, medical staff policies, your professional association guidelines, the hospital's malpractice coverage, your malpractice coverage, and by and large, be a good citizen at the hospital. This goes a long way as to the hospital's defense of you. So broad brush strokes, but I appreciate the opportunity to present this. Thank you.
Thank you, Bruce. Can everybody hear me? I'm Jeffrey Chou. I'm the co-chair of or outgoing co-chair of the Lumbar Spine Research Society. I think this was a great session. We have allocated about 20 minutes for discussion and question and answer. And I want to thank the speakers for keeping on time. I think this is the first webinar that the speakers finished within 5 minutes of the allotted time that we've been doing webinars and instructional courses since the pandemic began. One of the questions that came in, and I think this is for Bruce and Jonathan, and this has been a little bit answered, I think, in the context of Bruce's talk especially, but the question is specifically, are there situations where insurance carriers, even if they feel no malpractice has occurred, will settle a case to avoid going to trial?
I'm happy to give a little bit of insight. So I think the answer to that question, the short answer is yes. In fact, I would say that the overwhelming majority of times that the cases that we settle, it's because they want to avoid the risks associated with the trial. There's a lot of nuances that come with that. And, the question I think was specifically about insurance carriers. And as Dr. Darden pointed out, that there's a very big difference between the way malpractice insurance carriers handle things versus the way hospitals handle things. And so when the hospitals that are self-insured are determining whether or not to settle things, they have to take into different considerations. Whereas a lot of times what it comes down to for the malpractice carriers is whether or not the physician will consent. And that is often a sticking point because many times physicians just don't want to consent when they don't think that they've done anything wrong. And I don't blame them. And I like to think that we tend to put on as good of a defense as we can, that it often encourages the doctors to stand their ground. But there's a lot of risk benefit analysis that goes into that. And I would say that the majority of times that they settle those cases, it's because they're confident in the care, but there's a risk associated with it, whether it's a really bad injury or just some of the nuances, especially if there's finger pointing amongst others in the case, that can cause issues as well. So I think a lot of times that's a strong consideration.
So Jonathan, do you counsel physicians, or how do you counsel them when you see real problems in taking the case to trial versus the physician that, really does not want to settle? I mean, how do you handle that situation?
Sure. So there's a couple of nuances to that. One of the things that I always have to explain to physicians is that when we're retained by the insurance company, we represent the physician unquestionably. But if the physician has a concern about not settling, We can't really get in between that. We can report to the insurance company that the physician doesn't want to settle, but they will often go retain their own separate outside counsel, which creates a lot of different other issues that are a little bit more nuanced than we probably have the time to discuss. But what we often talk to the doctors about is, that a lot of times this is, while I recognize that this is not a business decision by any stretch of the imagination, a lot of times what you're doing is buying your risk. And we always tell the doctors, hey, listen, if you want to defend the case, we will defend the case. We're ready, willing, and able to do it. But there are times where you have to say, hey, look, we've consulted with experts. Our experts think that we have a real problem on this point. And even though it may not necessarily be something that was a deviation from the standard of care, there's an optics issue that might be hard for us to sell to 12 lay people who aren't going to understand medicine the way a physician does. And we sort of ask them to put themselves in the shoes of the layperson who may not understand it to determine what the risk is that we might lose the case. And throughout the case, we evaluate whether we think it's a case of possible liability versus probable liability in the exposures that could come. And, we sort of guide them throughout the case so that they're not just hit at the end like, oh no, I have to settle this case. And that's a decision that usually comes about and evolves throughout the course of litigation.
Fantastic. I have a question for Dean. Dean, I love that term that you use, cognitive load, when dealing with at least the intellectual aspects of having the burden of, if you will, having to go to depositions and train and go through all of the issues of preparing for a malpractice suit. In your research, did you come across, to use a different term, emotional load, the impact on your personal life and well-being? This is both for Dean and for Jonathan. I'm sure Jonathan has much more experience with this personally, but I'm asking Dean's expertise because he's hot off the press of doing a lot of research in this and has looked at the literature. Your thoughts?
I've not seen anything specific with regard to emotional load per se, but I certainly could see how that certainly would be a very big burden, an emotional burden. Just the whole thought of not knowing, you hear about people who, their loved one goes missing and then they turn up, 7 years later and it's closure. And I think that not knowing of what's going to happen with these lawsuits does create a big emotional load.
Yeah, I will say, I mean, in my experience, to me, it's the single biggest factor in why I do what I do. I love what we do and the nature of it, but I've seen physicians quit the practice of medicine because of cases. And one of the things that I think is that I always explain to physicians when I'm representing them is, medicine is an art. It is not a science. It is an art that uses science, and that it is rooted in science, but it is no doubt an art. And we always try to paint the picture that you guys have to make prospective judgments with the information that you have at the time. And sometimes that results in bad outcomes. And every person on the planet makes prospective judgments every day with the information that they have. Just the unfortunate thing is for doctors, if your prospective judgment leads to a bad outcome, it can be catastrophic or it can be injurious to another person, whether intended or not. And I always try to paint the picture for doctors that they can't beat themselves up in retrospect, because I always say, look, in my failure to diagnose cases, I'm not a doctor. I've never diagnosed a patient with cancer, but once the lawsuit gets there, I can always diagnose them 100% of the time with cancer, because now you know it. And it's easy to look in the retrospectoscope, but you gotta, and I see it take a ton of toll on doctors, and it's really disheartening because I think that they sort of probably take more on than they need to in terms of the way that works. And I see that they take those criticisms to heart. And it's also reassuring because it shows that doctors, in my mind, are out there really to help. There's not this sort of bad doctor out there who's just out there to make a quick buck. But yeah, I think it's very disheartening for doctors to be told that their professional judgment is being questioned.
That's great. So I want to talk about a specific complication, if you will, that was named in Dean's talk as about potentially being related to a large number of lawsuits. And and that's dural tears. Dean, one of your partners, Sandeep Kunwar, once told me, he says, "You orthopedic surgeons don't like seeing brain water, do you?" And I said, "Yeah, you're darn right. We don't like seeing brain water." But at any rate, the question is this: I mean, dural tears happen, not infrequently, and they're understandable, certainly in revision cases, and even in primary cases, they'll happen from time to time. And the risk factors that have to do with access and approach, and even obesity, and others that we won't go into. But my sense is it's not about the dural tear itself. It's about the recognition and management, and did you do the right thing by the patient? And so I'm curious, what is it that has led to the settlements? And is it the denial of the surgeon that they actually had a dural tear, or they thought that they fixed it and they didn't really fix it? And what are the aspects about dural tears that make it such a bugaboo in the medical legal world?
Is that a question for me?
That's for both you and Dean and Bruce, if it wants to answer it, and Mike too, for that matter.
Anybody else, by all means, please. Otherwise, I can certainly comment.
Go ahead, Jonathan.
Yeah, so I think you're absolutely spot on. I mean, every dural tear case that I've had, and I've handled plenty of them, has always been about the recognition and the management of it, as opposed to the actual dural tear itself. And I think that's because when a plaintiff's attorney seeks the consultation of the expert to certify the case, any expert worth their salt will have to look at them and say, hey, look, if I have to testify in this case, or when you go and get an expert to testify in this case, because it's not always the same person, you're going to have to be faced with the challenge of that expert, in the face of a good lawyer, is going to admit that a dural tear is a known and recognized complication, that they happen not infrequently, as you said, and that the simple fact that one occurs is not evidence in and of itself of negligence. And so when we get the experts to admit that, it goes a long way with the jury sort of understanding that okay, it's not really that they caused it, it's really about how they managed it afterwards. And I think that in terms of what drives either the settlements or the verdicts in those cases, I think that that's a very, very sort of variable answer. I actually have never had one that ever settled. We actually had the attorneys always dismiss them, because I think what they realize is that's not to say that they always would. I mean, I've been lucky, knock on wood, but I think that they realize that the challenge is that those things, not only do they occur, but they're not exactly the easiest thing to manage when they happen. I mean, there's sort of a standard way of approaching it, but they can reopen and they can cause other problems. And I think that the driving factor, I would say, in whether a doctor is going to defend their care is probably the timeliness of when they recognized it. And then often there's second opinions. In the majority of cases that I've had, they've brought in a second orthopedist during the care and treatment, and I've been able to use that person who's not being sued to establish that my doctor was doing exactly what that person did, which was the standard of care. And then they're faced with the fact that there's an independent person who has no dog in the fight saying, yeah, that's standard of care, that's what you would do. So there's a lot of, I think, complexities to what drives settlement, but I think timeliness is probably the biggest factor.
Right. Dean, anything to add?
No, nothing to add. I think that was great.
Yeah. So go on. Sorry.
I always think about that paper. Remember that called them an unintentional incidental durotomy.
Yeah, incidental.
Trying to make it sound as benign as possible. That this is normal.
That's my catchphrase in my operative reports, if I have one. This incidental durotomy. So the next question, and as for anybody in the panel, the idea of risk management. I mean, clearly the way to avoid being sued is, quote, practice good medicine. But from both Dean's or Jonathan's perspective, and also Dean and Mike and Bruce, what are the things that you find have probably kept you out of the courtroom and out of the attorney's office in depositions? What do you think that the things that we can do as spine surgeons to avoid having to deal with these sorts of issues?
from my perspective, everybody's going to have, surgical misadventures. I mean, we're training residents, we're training fellows ourselves, nobody's perfect. We're going to have these problems. And for me, it's always important to not be defensive when you're talking to the patient and the family, and to let them know right up front, that yes, we had a problem. This is what I think caused it, but I'm not sure. This is what we're going to do to look into it or treat it, and to keep them involved and answer the questions and be available. I mean, you don't have to be patronizing with it, but I think you have to be straightforward with the family, and I think that goes a long way into avoiding some of these suits. If you become defensive or deny or or, or change the record or anything like that, family's going to pick up on it. So that's helped me over the years, just to to take your lump straight up front and let them know that this was a problem and that we're going to address it, and this is what we're going to do.
Anybody else?
I think that's spot on. I think patient management, both on the front end and the back end, in my view, I'm a big fan of, and obviously if you're a hospital-based physician, this is done by the hospital, but I'm a big fan of when there are resources that are provided to the patient at the outset, that they can go and sort of see what the nature of their surgery is going to be and the procedure and what are the risks and complications. It sort of avoids that whole, they didn't tell me that was going to happen, because even when you're talking to a layperson, I mean, you'd be surprised, or maybe you wouldn't, how many times, for example, I suspect that there's a risk of stroke in almost every case that you guys do. And yet, in the vast majority of them, stroke is not something that's often discussed as a possible outcome, because it's so small in a lot of the cases. And then when somebody has a stroke following a surgery, whether it was related to the surgery or not, then they're in there saying, well, nobody told me I could have a stroke. And so I'm a big fan of sort of managing it on the front end, and then on the back end, being sort of upfront. Although I will say, and this is the defense lawyer in me, I caution all of you about how you approach that. I've had doctors who've allowed patients to record them and who've been in there being like, yeah, I'm just going to be honest with you, this was a total mistake. And then it's difficult for the lawyer on the back end to defend that. So, you want to approach it in a meaningful way, and not one that looks to deflect blame, but in a way that sort of acknowledges that these are complications. Surgery is not without complication, and we're going to address it and we're going to fix it. And we're going to do the best we can.
So we have one more question from the audience. Do the staff or the faculty use informed consent that requires patients to sign after each possible risk of surgery listed? Any advice on informed consents? Well, I'm going to say what I do. I have a document that I have my patients sign in the office that has a laundry list of almost every complication I can think of. But I also say at the end, as well as others not stated here, and I have them sign that. So if it's something happened that's not on the list, it's not there. I've been using that. It seems to work. And every once in a while there's a complication, and I said, hey, look at this thing. If you don't understand any of these questions, let me know. Most of the patients like to have, I think, the head in the sand approach. They don't want to think about it, but they sign it anyway. But I give them the opportunity to do that. First of all, Jonathan, is that a reasonable thing to do? Is it actually protective to do that? And does it work?
So I think the short answer to that is yes, but I think that it's certainly a reasonable thing to do, and I think that it has to be coupled though with the conduct. I mean, sticking a form in front of somebody and running through the list of those things and saying, hey, just sign this, and that I told you everything, and also this catch-all phrase. It's a perfectly good thing as a basis, but you want to make sure that you invite the patient to engage, and I think that. Oftentimes for me as a defense lawyer, and this is sort of a little trick of the trade, it's so much easier to defend a case against a non-engaged patient, against a patient who wanted to bury their head in the sand, because while I would never blame the patient, I can always paint the picture to a jury of, hey, look, we're over here trying and they're the ones that aren't, and so I think that, having the conversation with them where you're saying, look, if there are questions that you have, if there's something that you don't feel that I've covered or that you want to know, please let me know and I will be happy to take the time. I think that really goes a long way in being able to cover yourself of being able to say, look, I sat down with the patient. I talked to the patient. We went through these things. It's the doctors who spend, a lot of times I get in the deposition, the patient who, when I say, they went over the risks and benefits of the procedures, the patient's like, not really. I mean, they talked to me for 5 minutes and asked me if I had any questions, and what do I know? I don't know what to ask. Those are the ones that I think tend to have the problems, because it opens the door for the patient to say, hey, I didn't know about this. That doesn't mean you have to give them the laundry list of every possible thing that could happen, like stroke. But I think just inviting them to engage with you and coupling that document with the actual conduct of really engaging them and talking to them and making them feel comfortable, I think it goes a long way, certainly in ameliorating the risk. Whether or not it necessarily accomplishes the full legal benefit often depends on the facts.
I can ask a question. Sorry, just one more
No,
question.
no, go on, Mike. I've been hogging the floor here.
No, it's been great. So a lot of us use extenders for our informed consent. I'm not sure if the other surgeons on the panelists do or not, but how would you advise us, Jonathan, on using like a PA or a nurse practitioner or a resident to obtain a consent? And that conversation is done through an extender. Sure.
Yeah, it's a great question. That can be tricky because from a lawyer's perspective, the key to being able to defend the case, and I will tell you, I don't have a lot of informed consent cases where informed consent is the legal issue, but it is always a sort of nuance that arises in terms of, as I said, the patient always saying, well, I didn't know that was going to happen, or painting it out as if they would not have undertaken the surgery if they had known that there was this risk, even though the case is really more about surgical error or the postoperative complication. That still always is injected. And I think it's easiest to defend that when the person who's doing the surgery is the one who explained the risks. It becomes a little bit more difficult when you have a person, because if I were a plaintiff's attorney and I were deposing that PA, the first question I would ask is, I just want to be clear, you have never performed, insert the name of the surgery, and even though they may know all the risks and benefits associated with it, it goes a long way that they've never performed it. And so I think that it's definitely something that you want to be cautious of, and you want to make sure that your physician extenders, whether it's your APNs or your PAs, are very well informed about all the risks and benefits, and that they do much of what I just explained a moment ago, which is really engage with the patient and make the patient feel comfortable, like they had an opportunity to talk to just as if it was you. That you don't want to create that gap that somehow suggests, well, if I would have talked to the doctor, if I would have talked to the actual man running the ship, that maybe it would have been different. You want to make sure that they feel, and that you can paint, for lack of a better phrase, a defense that says, look, we gave you all the same risk. You didn't lose anything by not talking to Dr. Lee. Just because you talked to APN Johnson or PA Smith, you got the same thing you would have gotten from Dr. Lee. As long as you can create a scenario where that can be reasonably established, then it goes a long way in terms of protecting yourself, I think.
Well, I want to ask one more question, Jonathan. Do you ever run into a situation, because I think what many of us fear is that, what happens if we get into a lawsuit and it exceeds the limits of our malpractice policy? Maybe the hospital has a deep pockets and it's not an issue for hospital-based guys, but in private practice, we'll have 1 million, 3 million policies in California. We have this thing called MICRA that protects us a little bit in our state. Have you ever run into a case where physicians have been ruined personally because of medical malpractice settlement? Have you heard of that?
So I've not, and here's why. Because, and this is a very, I'll distill this down as small as I can, and it goes to the consent issue, but it's a very nuanced issue that happens almost exclusively in the malpractice carrier private practice issue. It doesn't really happen in the hospital-based situation, because those don't tell anybody I told you this, but they have insurance up to hundreds of millions of dollars, so multiple layers. So they're really, really worried about that. But when it comes to the $1 million policies, which is almost always at play as opposed to the $3 million in the aggregate, that $1 million, in order for that is the cap of the liability. And in order for the what will happen is it's called a bad faith claim, but in order for the attorney to be able to pursue the deep pocket of the insurance company, which is really what they want to do. They don't really want to go after a doctor. Not many plaintiffs' attorneys want to go after doctors like that, because at the end of the day, those are the same plaintiffs' attorneys that when they have a problem are going to need a doctor. And if they get a reputation in the community of being the kind of person that would ruin a physician, they're not exactly going to be, there'll be a pariah, and it's very, very rare. So what they do in order to try to, and on top of that, most physicians, I know you all do quite well, but you guys aren't sitting on usually palatial estates and millions of dollars when there's an insurance company that is. So what they do is they set up what's called a bad faith claim, whereby they have to make a demand within the policy limit. So it has to be the $1 million or something less. And if the insurance company refuses to settle, and if the doctor consents and says, no, you settle, then what happens is if the verdict exceeds the policy limit, then the doctor has a right to sue his insurance company or her insurance company for not settling it when he told him to. And this is convoluted, assigns that right to the plaintiff's attorney, who then pursues it and gets the money, collects the money afterwards. So the point is, it's a convoluted way of explaining that there is a mechanism in place that allows plaintiffs' attorneys to not go after doctors individually and ruin their lives. And the other problem with it is that defense lawyers like me, we know how, if there's issues at play, even though you're not really allowed to talk about insurance, we know how to pepper the jury with enough facts to make the jury feel uncomfortable about exceeding a policy limit if they think that the doctor's at risk. You can't ever talk about policy limits or know what it is, but there are tricks of the trade that can make juries feel uncomfortable, and plaintiffs' attorneys know that, and they don't want to do that. They want the jury to maximize what they'll give them so that they can go after the insurance company to get it. So again, I know it's convoluted, but hopefully that made some sense.
Well, great.
Mike?
Thank you to everyone. And Mike, anything to add before we wrap this up?
No, I found the whole session very educational. I want to thank all of our speakers. That was fantastic.
Thanks so much, and we'll see you next week.
Thanks, guys.
Thanks, everyone.
Thanks.
Bye-bye.
Take care.